Welcome, everybody. I'm Grace Wong, and I am the Director of Policy at the Asian Pacific Institute on Gender-Based Violence. Welcome. We're trying to share the latest news coming from the administration about some, policy changes. And before I get started, I did want to share with or ask Shirley. I don't know if there were any logistical questions or any information, if there was any information you wanted to share with the group before I get started.
Yeah, sure. Hi, everybody. My name is Shirley. I am the Resource Center Coordinator at API-GBV. Brittany, my colleague, and myself are providing some of the back-end logistical support to Grace on this webinar today. And I just have a couple of quick housekeeping things to get into before I turn it over to Grace. During the webinar, please put your questions in the question and answer box or the chat box, and Grace will do her best to address those questions. If your question wasn't answered, if we didn't get to it, you can always email it to one of us. We'll provide our contact information. Just remember what you're typing into the chat box will be public, so do not share any identifying or private information about survivors or yourself. We do have closed captioning today. We're in the process of getting that set up, and I'll message the chat once that's ready to go. The webinar will be recorded and shared with everybody after the call today. And I just want to thank you for joining the webinar. I'll turn it over to our policy director, Grace.
Thank you. And on that, I'm going to try to do this webinar, I'm hoping that if you do have questions, if you can put them in the Q&A section of the webinar on the under Q&A on the end, so that they'll, all the questions, how that functions works is, they sit there until the questions are actually answered, because if you put it in chat, it'll get lost in all of the string and I won't see it. But, I'll try to, deal with questions as they come up, if not, we'll do, try to answer them at the end. And if not, there'll be opportunities for you to enter them after at the very end of the webinar, and we can respond to them directly. And yes, thank you for the reminder of not sharing personally identifying information or confidential information about survivors you're working with, because we are recording this and it'll be available for people to see, later. So today we are, oh good, Brittany's got the slides up. We're covering public charge and its impact on survivors of domestic and sexual violence, as well as human trafficking. If you want to go to the next slide, Brittany. What we are going to cover today is, some of the context. Why are we talking about this today? And we'll talk about what's public charge, when does public charge show up, where does it come up, and how should we talk to survivors and their families about public charge and what's happening with the public charge rule. How can we have some influence on what it looks like in the end. And so just, so that you have the larger context. Next slide, Brittany. During the last administration, a rule was issued that really, I think, drove a lot of fear in immigrant communities, and it greatly expanded who the public charge rule, how the public charge rule would impact people trying to get status. It changed what kinds of public benefits programs were considered in making a decision on public charge, and changed, it gave a lot more weight to certain negative factors in terms of people who might not be able to get status because of public charge. That rule that was issued in 2019 was immediately challenged in litigation. And so in one of the cases out of Chicago, the district court found that the 2019 rule violated another federal law, the Administrative Procedure Act. And so that decision was appealed to the Seventh Circuit Court of Appeals, which upheld that the lower court's decision. When the administration changed in 2021, the new administration asked that the ongoing litigation be dismissed, and so the Seventh Circuit Court of Appeals decision ruling that the 2019 rule was violated another law and was therefore invalid. So essentially it struck down the 2019 rule, and the new administration dismissed all, their appeals of that decision, meaning that the 2019 rule went away. Unfortunately, there were oral arguments last week in a case where several states challenged, wanted to intervene in that Seventh Circuit federal court litigation, saying that, they wanted to pursue upholding the 2019 public charge rule. And so, we'll see what happens with that, because the Supreme Court has, they heard the oral arguments. Part of what's going on right now is the administration has issued, public rulemaking process with a new, written regulation, partly, I think, in response to the litigation, to make sure that they can come back to the court and say, we're issuing a new rulemaking anyway. So the whole, all of that litigation is no longer important, and the case is already, it's moot. So so that's what's going on in the larger frame or context of, there's been all these lawsuits challenging the last administration's rule, and the new administration is putting forth a new rule now. And so I haven't even gotten to the substance or the content of so what is this rule, but before I do that, I know there are many of you who are very familiar with this concept of public charge, but for those of you who aren't, I'm just going to give a little bit context of what is public charge, what's that even mean, how's that, when's it come up, that kind of thing. And so U.S. immigration law applies to, it's found in our federal law. If anybody wants to go read the immigration code, it's at 8 U.S., the whole chapter, 8 U.S. code. And immigration law applies to anybody who's not a U.S. citizen. So it applies to, a U.S. citizen is somebody who's generally either born in the United States or, derives citizenship from their parents because their parents are U.S. citizens, or they've naturalized. And so, immigration law does not apply to U.S. citizens. It does not. So, what we're talking about today, the public charge rule, does not apply to U.S. citizens. It doesn't apply to U.S. citizen children of undocumented parents or documented parents. It doesn't apply to people who have naturalized. And so, just be clear about that. Within U.S. immigration law, there is a whole section of law that is describes who is inadmissible, who cannot be admitted to the United States, either as a permanent resident, to get somebody to get their green card, or if they're, out coming in from on a plane and they have a visa, people can be turned away because they are inadmissible. And the law, which you can find around grounds of inadmissibility, there's a whole list of grounds of inadmissibility, such as criminal grounds, for example. There's grounds for, if you've entered the country without inspection, that's one ground of inadmissibility. There's grounds of inadmissibility for, having, certain health related reasons communicable to diseases. If you're, watching the news at all along the southern border, certainly the administration has used that, the COVID pandemic as a basis to deny a lot of people entry. But there is a longstanding ground of inadmissibility that's been around since the late 1800s called public charge. And what the law says that if in the determination of a consular officer or the immigration service, somebody who's likely at any time to become a public charge is inadmissible. And so that's what we're talking about here. That's what today's presentation is. It's about, whether or not somebody can, get a green card in the future, whether they can, enter in the country with a visa, et cetera. But we're talking about in the context of DHS, because the State Department issues their own rule of inadmissibility. And so I think they're waiting for DHS's rule to go through, and then they'll follow up. So, people that are at foreign consulates, they'll be referring likely to whatever comes out of this process. So next slide. Okay, so what current policy is right now is this was the guidance that existed in 1990, that was written in 1999, that was in the Immigration Services Policy Manual. And, this had been the practice since 1999 until now. Well, until the last administration issued their public charge rule in 2019. And then, and so that those cases, that policy applied for about, I would say a couple of months until, after all of the litigation, it went into effect for a little while, and then it got stopped and overturned. And so the current administration reverts back to 1999 policy. And what that policy is now, if somebody's going through their green card interview right now, they're going to use this public charge rule, which says that, that reminds the immigration officer that the public charge assessment is forward looking. It's like whether the person is likely in the future at any time to become a public charge. It reminds people about that, and reminds the immigration officer that not one factor alone is dispositive. And so, even if people had used public charge in the past, had used benefits in the past, that, it's still a forward-looking test. The law requires them to look at a whole totality of circumstances, considering the person's age, their health, family status, financial status, education, skills, that kind of thing. And the affidavit of support, the current policy really relies a lot on affidavit of support if somebody's willing to sign, essentially a sponsorship type document that says, like, I will support this person so that they don't become a public charge. And generally it's the person who's, petitioning for the incoming immigrant, whether it be an employer or a family member. But, people can get co-sponsors as well, other family members, et cetera. So if there's a affidavit of support that shows that there's enough income or resources so this person's not likely to become a public charge in the future, that is pretty important. Next slide, please. So just a reminder, when does the public charge test apply? We want to make this very clear. It doesn't apply to everybody at all times. It only applies in two main ways: when somebody's applying for a green card, or when they're seeking to come into the United States with a visa. Do keep in mind, though, that some individuals that live in the United States and return to their country of origin, sometimes they have to leave to go to do consular processing and get a visa outside the country. This is true a lot if people weren't lawfully admitted the first time. For example, if they entered without inspection, technically they're supposed to leave and do the process outside the country. And so, and it's important to know that it's not a consideration if somebody already has permanent residence, their green card, and they're applying for US citizenship. The public charge ground, it's a ground of inadmissibility. It's not a ground of, not a basis to deny somebody citizenship. And so it doesn't apply to family members who are not seeking permanent residence. For example, if you have a household of people and some of the kids are eligible for various benefits and are U.S. citizens, for example, or they're other undocumented family members who aren't seeking status. It doesn't apply to them. And so it's, the particular individual who's seeking to be admitted to the United States, the ground of inadmissibility applies to them. And there are a lot of categories of exempt groups of immigrants that I'm going to go through in the next several slides, or later on. So there are groups of people that the rule doesn't apply to because the law itself says these people are exempt from the public charge ground of inadmissibility. So next slide. Oh, one more, because we don't need to spend time on this. So on February 25th, the administration issued a proposed rule. For the most part, it puts into the regulation a lot of what was in 1999's rule or guidance, but it actually puts it into regulation form. And then there are some places where it's different because a lot has changed. There are new immigration categories of people. There's like a lot of different circumstances from 1999. And so there are a few little tweaks in here, but for the most part, it's the same framework. Can you, forward to get the rest of the slide to come up, the next two? Okay, so the proposed regulation defines somebody who's likely at any time to become a public charge. That's what the law requires, the basic law. It defines in regulation somebody who's likely at any time to become dependent on the government. So specifically on the government, not on, churches or local, nonprofits, or likely to become dependent on the government for subsistence. So for basic living. And, I'm noting importantly, primarily dependent, not just, because a lot of people get various public benefits, but that's, they're working full time, right? Primarily dependent on the government for subsistence as demonstrated by either the receipt of public cash assistance for income maintenance purposes. And what that means is, generally those are means tested benefits. And it has to do with, preserving having long-term or, medium long-term income. And so like one-time cash benefits would not fall into this. And we'll talk a little bit more about the specifics of this, or long-term institutionalization at government expense. And they use these were the rules in the 1999 guidance, and they're proposing to put that into the regulation now. Next slide, please. So they specifically mention in the proposed regulation and all the background materials what that includes. And so they talk about SSI, so supplemental security income, which is for folks that have been found to be, unable to work because of disability. Temporary assistance for needy families, TANF, or state and local cash assistance for income maintenance purposes. And so it doesn't include like special purpose cash, such as, childcare assistance or energy assistance, or, special reason, disaster related relief, pandemic assistance. Like I just want to say during the pandemic, I worked a lot with state and local governments who were trying to come up with, create COVID assistance funds for immigrant communities, especially those who aren't eligible for any kind of other relief. And, we really emphasized the importance of making sure that those packages were clear, that they were for an emergency, that they were short-term, partly to try to avoid any possible problems in the future. And that is why you will see across the country, states trying to come up, in some states, not all states, I wish more states, working on these types of emergency benefit programs. And they happen to be fashioned this way because folks are trying to avoid the longer term income maintenance type of program. It also doesn't include earned income, which is, stuff that you've paid taxes into, for with your earnings, right? And so unemployment benefits, tax credits, et cetera. And so, some of the things that the administration is asking for input on, because this is a proposed rule, speak to, what opinions do you have about whether these are appropriate in terms of helping determine whether somebody is likely to become dependent on the government for subsistence, right? And so, like I will say, we are going to submit comments that speak to specifically about benefits that survivors often use, speak to crime victims compensation, for example. I mean, I don't think crime victims compensation would fit. I doubt it would fit in there, but we would like them to clarify that more in the law, especially if it's wage replacement related. Okay, next slide. And then there's long-term institutionalization at government expense. This is specifically, as noted in the proposed regulation, medicated funded long-term institutionalization or state or locally funded long-term institutionalization, and doesn't include, other Medicaid. It doesn't include healthcare. It doesn't include home and community-based services or short-term rehabilitation. For example, somebody who needs short-term nursing home care to be able to return home, et cetera. And so these are what the two sets of types of benefits that they will be looking at to just determine whether somebody's likely to become a public charge. So the nice change about it, just a reminder, it does not include housing assistance. It doesn't include food assistance, doesn't include I'm trying to think, I can't even think right now of all the various types of benefits that are out there. There's a question right now that asks whether long-term institutionalization at government expense also includes incarceration. I think they're seeking input on that. And I think the one of the pieces has to do with whether that's, people's whether it's voluntary or not. I mean, I know that there's some parameters that they're wanting input on about, sometimes people are institutionalized in violation of the law. Sometimes the reality is they're institutionalized because the state doesn't have another type of resource for folks and people are waiting to get into some other program. For institutionalization, I would say no, but it's not definitive. And so I would if you have the opportunity to provide input that suggests that they be very clear that that does not should not, be clear that it's not part of the rule. I mean, part of the issue is, so the overarching rule is if they're likely to become primarily dependent on the government for subsistence. And I mean, there's questions if somebody's incarcerated, whether, well, first of all, I would say it's generally not voluntary, but I mean, they are, living. Yeah, hard to say. I would emphasize giving them input about that. And thank you for raising it so we can consider how to approach that as we go into the rulemaking process. Okay, I'm going to move on. Receipt of public benefits. Next slide. Okay, so what does it mean to receive public benefits? It counts as receipt when the person is listed as the beneficiary. So it's not for their kids. I mean, we see a lot of mixed status households where the parent is receiving benefits for a household on behalf of their children. And it has to be, when they've actually received it, not just if they've applied for it, or they've been approved for it, but they actually are receiving it now, or they received it in the past. So that's what it means, just because they're eligible. I mean, and people are eligible often because of their income levels. And some generally programs that aren't related to somebody's income level. And so that might go to your institutionalization question in incarceration. It's like, it's not based on your income. And so that's one of the arguments that if somebody were to go into an interview would say, like, if it's not related to your income at all, that would be, yeah, I mean, all of these things, you're generally, these are programs you're eligible for if your income allows that. But just because you're eligible because of your income doesn't mean that you've actually received the benefits. So, a finding that you're eligible is not going to count against you. So next slide, please. Okay, just if you can click through, because I didn't realize that this slide had all these like in and out. So the law requires them to look at, at a minimum, all of these factors: age, health, family status, assets, resources, financial status, education, skills, affidavit of support. And there's a reminder that not one factor, other than the affidavit of support, when required, can determine whether somebody is likely at any time to become a public charge. And so current and past receipt of benefits on its own is not enough. And a finding that somebody's disabled is not enough. And for us, working with survivors of domestic violence, I mean, these factors are challenging, right? Can be, not always, but can be challenging for individual survivors, especially as it relates, to family status, where they may be, have lots of kids and are separated from a partner. And so there's not other income. They may not have assets. These are challenging things for us. And so, some of the comments that we intend to submit, will speak to, some of the purposes of the laws that protect survivors. And they are specifically seeking input from the communities and from commenters about whether or not, how they should consider each of these factors. And so, like in the 2019 rule, right, the regulation had talked about some of these factors and had put really hard line rules around, like, if you don't have income over a certain amount of time, certain amount level over the poverty line, or if you don't have any, if you haven't finished your education or some of those other things, then, the last administration's rules were explained how to weight all of those things. And this proposed rule doesn't have those specific guidelines yet. And so it's our opportunity to provide input about how they should consider all of these things. And so, we know, for example, just because somebody is older doesn't mean that they're unable to work or support themselves or don't have family members that can take care of them. Just because they are separated from their, they're not married and have, various kids doesn't mean that, as the kids get older, that they can't work and support the family. All of these different things, of course, we want to make sure that they consider the likelihood that somebody's going to be able to, if they're admitted for residency, admitted to the country, they'll be able to support themselves. And then that affidavit of support will be really important. And so, I mean, the reality is, with the 1999 guidance and if this rule goes into effect, if somebody is able, I think the vast majority of people, they find a sponsor, a co-sponsor, who's willing to submit an affidavit of support so that they can show that they're not likely to become dependent on the government for subsistence. Okay, next slide, please. So, there will be the regulation, and then, so this is where, they're seeking input. The USCIS DHS may also give more guidance in their policy manual besides the regulation. So that's why they're seeking input. The proposed regulation does require that there be an written denial decision that considers each factor and articulates why they made the decision that they did. And I think this will be really important for those working with folks who might possibly be denied to be able to respond to that. And so, okay, I'm going to move on next slide, exempt groups. And this is like, there's probably about, if you look at the statistics from USCIS, probably about a third of people who got their green card over the last 4 or 5 years fit into an exempt category, somewhere between 27 and 30%. And so this is a big chunk of people who are applying to get their residency. And so, it'll be important to know who, remember, like, there's public charge, the public charge rule. Folks are as people are considering whether or not to apply for certain benefits, most people who are actually eligible for at least the federal benefits, are exempt in one of these categories because, a lot of those federal, at least the TANF and the SSI and Medicaid, like a lot of people aren't, that might not fall into an exempt group aren't even eligible for those programs. So it's just, people, we had so much confusion and worry from the last administration about all the different ways that people wouldn't be admitted to the country. So just like that overarching thing, a reminder that there are a lot of groups of people that are exempt, but there are survivors, that are not exempt. But in any event, so refugees, asylees, Amerasian immigrants, when they first come into the country, and first get their refugee status or asylum status, and when they go on to apply for their green card, they are exempt from the public charge rule. Folks with NACARA, so Nicaraguans and other Central Americans, right now we're seeing, some of these folks, the Afghan and Iraqi interpreters and nationals that were employed by the US government who, have the special immigrant visa category, they're exempt, as are special immigrant juveniles. So these are abused and neglected kids who it would be in their best interest to be able to get status. Cuban and Haitian entrants, I don't know how many people we're seeing now that entered before 1972, but folks that are eligible for registry, they're not subject to public charge. Next slide. Folks applying for TPS or temporary protected status, and that is a set of programs where the federal government decides, okay, there's a lot of turmoil going on in your country, whether it be, for example, war or a major natural disaster or some type of health pandemic, whatever. The federal government declares a certain country, nationals or citizens or nationals from those countries that happen to be in the United States, they can sometimes get TPS. And so in our country right now, there's probably like a dozen countries where there's ongoing temporary protected status allowed for various countries. And then certain foreign government non-immigrant visa holders, these are generally like diplomats, et cetera, who are exempt from public charge. And then this category, these groups of survivors of domestic and sexual violence. So these are VAWA self-petitioners, abused spouses, children, of US citizens or permanent residents or abused parents of US citizens who have applied through the VAWA self-petition process. And, this is one of those things that, sometimes when you're working with a survivor and they're trying to figure out whether or not they want to apply for VAWA or not, because their spouse is sponsoring them and, they're in an abusive relationship. And it's one of those things that people talk about, well, if you go through this route, the VAWA self-petition process, public charge doesn't apply to that category of people. Also doesn't apply to certain people who have been battered or subject to extreme cruelty by their US citizen or permanent resident spouse or parent. Generally, this one, even if they go through the family visa process, they may be able to seek the exemption. They would have to affirmatively let the immigration officer know that they fit into this specific category in the law. And so that's, they can go through that. The question just is, like, if they're going through the process with their abuser, how the agency, sorts that out. So there's that. The rule also speaks to exemptions for T visa applicants, as well as people who already have a T visa and are applying to adjust their status. Same thing with U visa applicants and U visa holders, U visas, folks with U visas seeking to get their green card. Now, there are some people, just to flag for you all, this is a really technical thing, but I know many of you work with people that have T visas or NU visas. If they are applying to, so somebody who has a trafficking visa or a crime victim visa, U visa, they, for example, they end up being sponsored for permanent residency. Maybe, like they haven't, it might go faster if they're sponsored for permanent residency, or they're married to somebody who's being sponsored by their employer. So this is a really specific fact scenario, but the regulation says that if they are adjusting their status to get their green card through an employment-based visa, so very specific, if a employer is sponsoring, for example, their spouse and they happen to be married to them and they have a U visa or a T visa, so they're adjusting their status through the employment process. In that instance, they're required to get an affidavit of support from the employer. And so it doesn't actually say that they're subject to the public charge ground of inadmissibility, but it just specifically say they have to get an affidavit of support. So it's a very technical, specific thing for that group of people who happen to be getting a green card through an employment-based process. So most people aren't. I mean, if they have a T visa or U visa and they're getting their green card, it's through the T visa process or the U visa process. Okay, on to the next thing. Next set of folks who are exempt. Folks that, these are very, very small, discrete groups of immigrants, but sometimes you don't know, like you figure out that somebody fits into one of these categories. And all of these, other than the Native American, the American Indians born in Canada and the Texas band of Kickapoo Indians, all of these other categories happened to be, specific creations that were attached to a bigger budget bill at one point, trying to protect a group of specific. So, for example, Liberians, it was a unique set of folks that were able to get their status in the last few years because of a bill that was passed a couple years ago. Same thing with certain Syrians and Polish Hungarians and very specific category. So that if you're coming across a survivor who happened to be in this country because they came in on one of these programs, they are exempt from public charge. So, but they're all going to be listed in the law under the immigration code in the section that's cited right there. Okay, next slide. Okay, so here are a couple questions, and I'm going to try to respond to a little bit of the questions that are the last question that was posed as we go through this. Next slide. What do we tell immigrant survivors and their families? And so I've tried to put together a couple fact scenarios where people might be wondering, it's like, well, how does the rule work in my situation? And so why don't we go on to the next slide, because the same questions are here. So, for example, we've been hearing a lot about this. I was just granted asylum a few months ago. Can I go get COVID tests and vaccines, or will that stop me from getting my green card? And so this is I think this one's very safe to say, no, you're not subject to public charge. You don't have to worry about it. First of all, the person is exempt from the public charge rule because they're an asylee. And so you'll want to remember all the categories of people that are exempt. But actually, that's not even relevant, because if you look at USCIS's page, they have specifically said that COVID-related benefits, vaccines, testing, that kind of thing, will not stop you, will not impact your green card application. And so, as the proposed rule, both the 99 guidance as well as the proposed rules say that Medicaid itself, if somebody needs to go in and get care, that's not considered as either. Next question. I'm pregnant and need help. I'm currently on, Medicaid, but I'm afraid it'll be used against me. So you can tell this person the public charge test will not consider Medicaid. Like I said before, we encourage you to go get the health care that you and your baby need. So there's that. Okay, next one. I lost my job because my employer went out of business during the COVID closures. Can I accept cash grants that the city is giving to immigrants? And if I apply for unemployment, will it hurt my green card application? So public charge test does not apply to benefits that are not cash assistance for income maintenance. So those one-time emergency grants, short-term emergency grants for a specific purpose, they don't trigger the public charge. They're not considered for public charge and assessment. Also the proposed regulation, there is specific about that. Same thing with unemployment. That is, an earned benefit that you pay taxes for. That is listed in their special purpose emergency, benefits income, and it's not an income. It's actually an income replacement, not an income maintenance benefit. So, they do specifically talk about unemployment as an earned benefit. So that's that scenario. If you want to go to the next slide. So the domestic violence program has an opening in their transitional housing. I'm worried if I use it, I might hurt my immigration status. And we heard this a lot during the last several years. We heard a lot of stories about this during the last administration, but the 1999 guidance and the proposed rules, say that housing, victim services, all the things that all of you do, like that, even if you're paid for out of TANF, TANF from your state, like if TANF is paying for housing, for example. I mean, in some states, I know that TANF pays for that, or if TANF pays for victim services. Housing and victim services are not cash assistance for income maintenance and should not be, aren't going to be considered, shouldn't be considered in a public charge. Whoops, that's an error on that slide, in a public charge determination. And so I'm just gonna go right here and talk about the somebody being battered or subject to extreme cruelty. When somebody goes for their application, submits their application for their green card, and they, usually there's a box that checks, whether or not you fit into one of those categories. It'll be on the form that will say, I don't have to do this, I fit into this category. And so typically the proof, like if you've ever helped somebody with a vow of self-petition, if they've got documentation of having been abused by their US citizen spouse or permanent resident spouse or parent, submission of evidence of, protection orders, medical records, for extreme cruelty, usually a declaration or statements from friends or witnesses should be sufficient to establish that. So, that's just very specific to, a category of person who is not specifically going through the VAWA process, but is going through maybe the family process, and they are potentially exempt from the public charge grant. Okay, here's another one. I am on a student visa, was raped after a university event. I'm worried if I go to the hospital that using healthcare might impact my visa. And unfortunately, we did hear about these cases during the in the last 4 years as well, of people, at least one survivor with horrible injuries. We heard about, not wanting to get a rape kit done and not getting any services related to that. So use of medical services, free counseling will not be considered in a public charge assessment. Next scenario that I imagine we'll see a bunch. I have a pending U visa and I have received cash assistance for me and my US citizen kids. Oops, I could have left out the US citizens. Should I disenroll so it doesn't hurt my chances for a green card? So this is, so first of all, the public charge test doesn't apply to the kids, the US citizen kids. It also doesn't apply to US U visa applicants or U visa holders. So, go ahead and get the cash. In cases where, the parent, the survivor is not in an exempt status, the DHS will need to consider looking forward whether that person's likely to become primarily dependent on the government. So even if they have used cash assistance for income maintenance, they'll look at the totality of the circumstances. I don't know how many programs exist out there. Hopefully there are more and more, but I know most of the programs that states and local governments are putting together are not going to be income maintenance type programs, but rather like short-term cash assistance if people need it. But most people aren't going to be eligible for some kind of, government income maintenance program anyway. If they are, if they're not already in an exempt category. So, the sets of people that will fit into this particular scenario aren't that many, but, keep in mind just in, well, first of all, refer folks to experienced, immigration attorneys or representatives. And, really, if people have received cash assistance for income maintenance, talk through, like, I think that's a factor to do in terms of safety planning, deciding, what you need now to be and stay safe and overcome abuse, and talking through the pros and cons. But the reality is if the person's if they're getting a U visa, they're going to be exempt from the public charge grant anyway. And if they're not in one of the exempt categories, it's not likely they're going to be eligible for one of these programs. So, and short-term emergency assistance is, it's specifically not one of the sets of benefits that they are going to be considering in this rule as they move forward. So next slide. Okay, so I keep talking about, like, right now, the proposed rule says this. Right now, the proposed rule says that. And so there are still opportunities to influence it, to hopefully make it stronger. And they have chosen, oh, can you push forward so the rest of the text comes in? Okay. So DHS has issued, first they issued an advance notice of public rulemaking that initially, because seeking input about what we should include in the proposed rule. They did that back in December of last year. And, many of the immigrant advocates, the Protecting Immigrant Families campaign, they submitted a sign-on comment, as did the Alliance for Immigrant Survivors, and many of our colleagues that are at the national and local and state levels too submitted comments on, like, generally what should be included in this in the proposed rule. So in February, about a week and a half ago, DHS issued the actual notice of public rulemaking. And these are the factors that I'm talking about now that are included on these slides, like what they have proposed to do. And so they're accepting comments until April 25th. Many of us are going to be working on comments, and we're going to be organizing some sign-ons. The strategy that people have put forth this time is to not inundate them with a lot of comments, because back in 2018, when the last administration issued a rule, they got over 200-some thousand comments. And the administration actually has to go through and review all of those and look, consider what people submitted in those comments. And so the strategy, at least for those of us who are, working with immigrants communities, are like, we don't want them to get 200,000 comments unless they're like, yay or nay, or, very like, so that they don't have to spend a lot of time reviewing for unique comments. But there are going to be some particular, substantive comments that are submitted. And we at the Institute are working in partnership with our colleagues through the Alliance for Immigrant Survivors to coordinate a set specifically about the needs of survivors of domestic and sexual violence. But some of the things that they're asking for include, how can we mitigate the chilling effects among US citizens or among people who are exempt from the rule? How do we mitigate them, like reduce the fear that they have to, access benefits they're eligible for? They are asking for input on whether primarily dependent on government for subsistence is an appropriate standard, as opposed to like whether it should be a greater or lesser level of dependence on the government. They're welcoming input on whether to consider non-cash benefits for supporting a family. I know some of us are going to put comments in that speak to not counting state and local cash assistance. They welcome comments on, non-federal programs specifically, especially if they're ones targeted at individualized populations, like maybe children or survivors or disabled folks or whatever. So, or maybe, we have an influx. We'll be having an influx of arrivals from Ukraine, I imagine, and also, the Afghan arrivals, like whether cash programs for them, whether they should be exempted. They're looking for lots of comments on what they've included in this proposed rule and what our input is as communities. Next slide. So somebody's asking about links, right? And so for those of you who want it directly from the source, the USCIS has a resource page on public charge specifically about what they're considering right now. The second link that I have here on the rulemaking page is the Federal Register page, where people can go and submit comments related to the rule. And so, we'll encourage you to do that, or if you want to engage in some of the larger activities that some of the national organizations and we are coordinating. There's the Protecting Immigrant Families campaign that is a whole coalition of lots of people working on access to public supports, benefits, healthcare, et cetera, for immigrant communities. There's the Alliance for Immigrant Survivors, of which, API-GBV, along with ASISTA, Immigration Assistance, Esperanza United, and Tahrir Justice Center, we co-chair a coalition, the Alliance for Immigrant Survivors. This is our apologies, the Alliance for Immigrant Survivors is, we work on immigration-related policies related for survivors. And if you want to engage more in that, let us know. There will be a survey at the end of this presentation for you to get more information, or let us know that you want to get more updates to be able to participate. And then just as a resource, more generally, we have on API-GBV's website just a general advisory on the impact of the public charge rule for survivors. So I think that's my presentation. And so let's see if you have any questions and answer or questions, go ahead and put them in the, actually, I'm going to ask you to put them in the Q&A box because I have not looked at the chat box for a bit. If you have any questions now, go ahead and put them in. But otherwise, you know, I'm done with what I have to share. Yeah, so I will just sit here and wait if you have any questions, but if not, I'm done with my presentation. So, and you know, thank you very much for getting on, participating. And I hope that you all will, you know, engage with us at AIS, or, you know, in the larger Protecting Immigrant Families campaign in, you know, sharing. What's really helpful, I think, is sharing experiences of the survivors you work with, letting us know about what impacts there are. And actually, if you have questions as you go along, like if you're working with a survivor and it's so hard to figure out what to tell them about their particular situation, you know, that we should let the administration know about, please weigh in, you know, put it in the survey at the end, or you can email us. So, yep. Do I have any more?
Thank you, Grace. And you did not miss any questions in the chat box, I don't believe.
Oh, good. It was all clear as mud, right? No.
I know there was a lot of information shared, so we will be passing around the recording once it's ready, the slides, and then the advisory that I dropped into the chat box. That will all be available. Yeah. We'll send it in a follow-up email because I know there's a lot to absorb in 1 hour's time.
Yeah, and then also let us know, you know, if you want to join Alliance for Immigrant Survivors, our mailing list. Let us know in the survey information. You know, we of course are going to be tracking what's happening with the litigation. So yeah,
I'll drop the sign up for AIS in the chat box.
Okay, too. Thank you.
And then the survey that Grace mentioned will pop up in your browser after you close out of this Zoom. Oh, there's one question.
Yep.
Okay, yeah. Okay, so we'll wait for Grace to.
Sorry, I'm typing.
To respond to that question. If you have any additional ones, you can send them in the survey, or you can get in contact with me. I'll drop my email in the chat in case you need to get in contact. And thank you so much for being here today. And take care. Happy Thursday.
Thank you, everybody.